Hello, welcome to the DMH Stallard Employment Group podcast. Today we're going to be talking about the risks and rewards of WhatsApp and other messaging. And the context of this is obviously the rise of WhatsApp from a personal messaging tool when it was launched back in 2009 to one that we see increasingly used in the workplace. And that's particularly so in Europe compared to places like the USA, where services like Slack are more prevalent. But actually, irrespective, I think, of the particular service used, that there's a common thread, which is it's very tempting to use instant messaging services like this to gain benefits for business, given that they're so intuitive, fast-paced as communication tools in the workplace. And obviously quick interaction like that mimics more closely face-to-face conversation and can, in theory, significantly boost productivity compared to something like email. But there are inherent risks, and as lawyers, obviously, we'd always be cognizant of those in terms of both data security, thinking of the US government's Pentagon group chat leak, for example, and for employee relations, given the informal nature of these services, and that increases the risk of inadvertent or inappropriate comments and material being shared, and a blurring of lines between work and home chat. And what are the potential impact of the services on work-life balance, where again, we see a risk there around the inverted commas always on culture. So how does an organization strike the right balance between managing risk without stifling productivity and creativity? With me to provide a fresh take on these issues are Holly Ryan, partner in the employment department at DMH Stallard, who helps employers navigate thorny employee disputes and defence tribunal claims where WhatsApp and instant messaging services can often feature. Hello, Holly. And we also have Nick Billen, partner and head of DMH Stallard's Dispute Resolution Group in Guildford, who advises businesses of all shapes and sizes and across multiple sectors on commercial disputes where either data security is the issue or the vagaries of disclosure requirements in civil proceedings bring it to the fore. So welcome to you as well, Nick. So we're going to have a good chat today. This is obviously an issue that's changing all the time and that presents different problems in different ways for different organizations. So getting stuck in then, Holly, starting with you, and it's a big risk that you and I actually see writ large every day as labour lawyers or employment lawyers. Can you just give us a sense of where we are right now in terms of the prevalence and impact of messaging services like WhatsApp in employment disputes? Do we see a disproportionate number of scenarios gone wrong as labour lawyers, or should this be keeping employers rather up at night?
Yeah, good question, Adam. So I think we're certainly seeing an increasing trend of WhatsApp being used in the workplace, which is no surprise really, given how many people use it globally. It's an estimated about 2 billion people. And whilst WhatsApp and kind of other similar messaging platforms that you mentioned can have huge benefits, employers do need to be alive to the risks in order to better protect their businesses. I think where we're seeing issues arise more frequently, as you said, Adam, is in the context of employee disputes, and whether that's in internal disciplinary and grievance matters or tribunal litigation as well, and then stemming from those disputes also in data subject access requests. It's no doubt WhatsApp and those instant messaging platforms are kind of a much more informal way of employees keeping in touch and progressing things without kind of being drowning in emails and getting a quick response. The downside to that, of course, is that inappropriate comments or jokes can easily be popped into a WhatsApp or group, message, which can cause offence to other employees, and in the extreme, allegations of kind of bullying, harassment, or even other employment-related claims. And then the risk there, obviously, for employers is that even if the messages are sent on employees' own personal devices, if the conduct is carried out in the course of employment, so it's a work-related group chat, the employer could be vicariously liable for the actions of that particular employee. And I think then leading on to kind of when those disputes arise, if then employers have a dispute and there is evidence stored on devices, there can be a need to disclose that material if they are work-related devices. A little bit tricky, and we'll talk about that a bit more later about the extent to which those kind of material needs to be disclosed. And I suppose the other area for legal risk that we don't often think about is employees sharing sensitive data on those messaging platforms. So whether that's client data, patient data, if the White House can accidentally add someone to a group chat, I'm sure employers can as well. I know it wasn't strictly WhatsApp, but it's other similar platforms.
Yeah.
So, I think employers need to take stock and think, how vulnerable is my business to an employee sharing kind of client or sensitive personal data with the wrong person. It can be incredibly risky if we're in data breach territories. They've got very expensive, you see eye-watering sums, don't you, being awards being made, fines being made, sorry. And we've seen an NHS trust, I think in the last couple of years, get caught out by this when employees were sharing sensitive personal data, patient data, and a non-staff member was inadvertently added to a group. And whilst that didn't result in a fine, I think only because the ICO recognised that the taxpayer would be bearing the cost of that fine, it's incredibly embarrassing for that organisation from a reputation perspective. But also in that particular case, they had to put certain measures in place, including, I think, things like, explaining data protection responsibility to staff, reviewing internal procedures for reporting breaches and what their policies were. So that's something that I think is often overlooked and is something employers should certainly be mindful of. Should employees be able to share sensitive data? Arguably, I think it should be prohibited because of the risk I've outlined. And I think the final point, I think, on risk here, and also it stems and can lead to a dispute, is what happens when someone leaves employment. So what information do they have on their phone? If an employee can leave with their phone and or even their phone number, they've got their phone, they've obviously got access to client data, and information on that phone. But equally, even if they're left, and often it happens in a settlement agreement, you agree that someone can retain their mobile phone number, they can effectively restore WhatsApp messages. So you're letting them leave with a lot of potentially sensitive information. So there are several risks I think that employers need to be mindful of when navigating WhatsApp messaging and other instant messaging platforms within their organisations.
Yeah, I mean, that's a great summary of just the various areas that this touches on. From my perspective, you often start from just that viewpoint of it's about communication between employees, and therefore it's a hotbed of evidence and written record of comments, etc., but you feed into data security and sharing of information, as you say. And I think we'll touch later in the session on things like the issue of do you permit your people to use their own device? Do you give them your device because you get greater control? And so it leads us neatly, Nick, if we just bring you in on the point around disclosure exercises now, which obviously feeds into this question of whose device is it to a degree. Are you seeing a prevalence, and what's the prevalence and importance of these instant messaging services now compared to, say, 10 years ago?
I think it depends on the individuals, but as Holly rightly said, it's so quick and easy these days to send messages on WhatsApp rather than send an email. It's so quick, it's accessible, it's informal, and we're seeing it quite a lot in business context used for discussions, even in forming contracts or in discussing issues that the business is facing. And that in of itself can cause significant risk for the business that Holly's just mentioned. And I know we're going to come on and look at it as to the oversight that might be needed in respect to these messages and proper management. But I think from a litigation perspective, with this blurring between the personal and the professional, that's somewhat in the background, because when it comes to disclosure in litigation, as you know, you're under an obligation generally to disclose what is in favour of and contrary to your case. So you can't just sit there and say, well, we're not going to look at those WhatsApp messages, we're not going to consider them. You have to. You almost have an obligation under the court rules to do so. But then obviously you're going to have to look carefully around other issues around data protection, the policies the business has in place, looking at GDPR, etc., which again I know we'll talk about as well. I mean, recently I've had WhatsApp messages used in a number of cases, and they are definitely not something the employer would have been happy to see its employees were writing, quite frankly. They were making jokes, they were sharing personal opinions about matters, some of which were very derogatory and probably using language that nobody is proud of, but the employer was under an obligation and duty to disclose them. Again, we did have some difficulties, as Holly mentioned as well, with this blurring between what's personal and what's part of the business as an asset. Is it the business's phone number? Is it their data, therefore, that the individual can use it for the purposes of their business? Or is it their personal phone number and their own personal WhatsApp messages? And we have had it also in circumstances where an individual has left and the business has taken that mobile phone back and it's sitting there. And then you have to think very carefully on the basis of, we know there's information on that is going to be relevant to the dispute, but how much can we use, bearing in mind our obligations? So it is definitely something that we're seeing used more. It's the quick and easy email of today's day, really, isn't it?
Yeah, and I think as a question comes up for organisations, it's not as simple as saying, well, we'll push all of the messaging onto personal devices, and therefore it's not data that we process, it's not our data. Quite apart from all the complexities of actually disclosure obligations, whether that reaches into your workers' devices, we see it, don't we, Holly, that that definitely doesn't get you out of the woods, because the opponent will have been a recipient of the messages. So even if you don't hold them and disclose them, it may well come out through your opposition's disclosure. So is it better to actually put your arms around it and say, look, we have to accept, if we're using this messaging service, there'd be relevant stuff on it, and it'd be better to be aware of it and put it in a clear box of parameters of how we use it, etc. I mean, we see that a lot, Holly. You'll get a disclosure item that no one our employer management level didn't have any knowledge of.
Yeah, more frequently than we'd like.
Yeah, well, that's right. Yeah. Yeah, thanks, Nick. Taking just one aspect of that, which I think we probably, Holly, could equally apply in the context of employee terms and benefits agreements. But what's the state of play around these messages in this sort of fora being used to actually construe binding contractual agreements or offers? Is there any less weight put to these messages? Where are we at with that?
No, and it's interesting that you raised that, because there was a case just literally a couple of months back where the High Court decided that WhatsApp messages had constituted did constitute a valid contract, and it's the case of JV Holmes and Fincham. And it's great because it shows that you have to be so super careful about what you're agreeing and what you are putting in writing, regardless of whether it's WhatsApp or not. Because as we know, under common law, for a valid contract, you need, amongst other matters, agreement, contractual intention, and then consideration. And a contract doesn't have to be in writing to be valid. And an informal to and fro of messaging between two individuals on a WhatsApp could easily make a valid contract. So in this case, the company brought a claim against a demolition contractor, arguing that a formal written agreement was needed for the works to be undertaken. And the defendant said, well, hang on, there's a contract. We've had an exchange of emails and there are a number of WhatsApp messages, and that is our contract. And the company obviously decided that that wasn't right. It disagreed with that concept. And so it sought declarations from the court that the defendant was wrong and the contract was subject to its terms and conditions. And the court looked at the toing and froing of messages and reviewed them. And basically, the judge held that exchange was a valid agreement between the parties, even though it was informal, even though it was a toing and froing of little messages here and there. The parties had agreed to price, they'd agreed to scope, they'd agreed to payment terms. So that is a legally binding contract. And I think that is a big reminder for us all that if all the essential elements of contract are present, you don't need a document that you can wave at someone to say we've got a contract. That is good enough. Yeah. And businesses need to be really, really mindful of their obligations on all digital communications being sent, however informal, because a quick exchange of two individuals might inadvertently lead to you committing the business to significant obligations from a contractual perspective.
Yeah, well, no doubt it did in this case, given it got to where it did in proceedings, that it took the unfortunate out of the result of the decision side of the dispute into a place that it didn't intend to be, quite materially by the sounds. And there's an added layer for the employment context, because as case law currently stands, I think it's pretty well settled legal position. There is a presumption of intention to create legal relations if an employer, let's say line manager, is talking to an employee, unless it's expressly stated otherwise. So you're already in a presumption there, and it means, for Holly and I, thinking about discussions that are had about bonuses, scheme rules, maximum payouts, that probably there's lots of discussions going on things like WhatsApp, and that at least one of the two parties to discussion think that none of this is binding. It doesn't stick to me later. I'll just say this because it'll get things moving, etc.
Yeah, picking up on that point, Adam, I think one of the key things to ensure is happening is to make sure that there's a sufficient training within the business, obviously around everything, but particularly in relation to these types of communications, so that the employees know that if they are using them, if they are having these types of discussions, they can use wording such as subject to contract during the exchanges. And if they do that from a very early stage, then at least in some way the business can try to control the contracts being formed.
Yeah, absolutely. I mean, control's a good point, Holly. If to come to you on it, do we think employers are doing enough to control the data flows, or even actually, it comes back to the point Nick just made about training, to understand, or maybe more of rather than training, but audit? Do they understand the nature and volume of the content that's flowing between individuals in their workforce?
I think most employers won't really have any idea what information's being sent to, between their work, their employees. Some I think adopt, and then I suppose into that, then what approach they then take to protecting that data. I think some employers are kind of fearful of this type of communication and have gone to the one extreme of banning it. Because they are alive to the risks, even if they haven't really investigated what those might look like. But I suspect the majority are pretty blind to the risks that we've outlined, and won't know the extent to which their employees are using WhatsApp. I mean, they might have some form of internal messaging system, in which case they might be a bit more relaxed about it, but I suspect most won't be. And I think employers can and certainly should do more to safeguard their data and understand kind of how these platforms are being used amongst their workforce to ensure that they better protect their positions. And as Nick mentioned, appropriate training is rolled out. They can then implement clear policies and guidelines around appropriate use and ensure that they've got policies around monitoring, so employees know what they are doing, where what they should be doing, and effectively that that there are reporting mechanisms in place as well, if something has gone awry, and training's rolled out to staff, not just once, which is often the case. You do one bit of training, tick that box and it's done, but there is regular and appropriate training to staff around kind of appropriate use, and it's it goes to, it can be part of wider training just about respect amongst your colleagues and that kind of thing from an employee perspective in terms of how they should interact with each other on these kind of platforms.
Yeah, I mean, I don't think any of us in this discussion are sort of advocating a blanket ban. It's probably not. I mean, let's put the Pentagon sort of scenario aside, where maybe in that extreme scenario you might be, but it's probably not realistic to think that you could actually completely eradicate it, is it? So then it's that point about the middle ground between allowing it but having the right balance of controls and freedom, which is really tricky to strike, but that's really what we're talking about, isn't it? And some of that is based on, you need to educate and have processes that mean you can be more comfortable with what's going on in the organisation.
Yeah, and even if organisations do ban it, there's still a risk that it's still ongoing in the background and they've got no idea what they're doing. So I think you're right. It's putting appropriate measures in place just to safeguard the business's interest and better protect that kind of sensitive data.
I mean, Nick, I've kind of raised another problem, haven't I? Even with just in that point about audit, because even the idea of just understanding the issue and in order to address it is not completely straightforward, because that is probably going to involve some degree of increased surveillance of workers' communications. I mean, where do you start with that so that they don't, an employer doesn't try to solve one problem and expose themselves to litigation with workers about, snooping and spying on their messaging?
Yeah, you're absolutely right. It's such a tightrope to walk, isn't it? Such a careful balancing act. I mean, I completely agree with Holly. It's making sure you've got all of these clear policies and training, so that employees know absolutely what they can and can't do, and more importantly, what the employer can do. Because there's a real danger, as you say, if the business doesn't get it right, you've got a big risk of litigation, but it could also impact the work environment. And every business wants to make sure that it's maintaining a positive and productive work environment. So it's about proportionality. It's an easy word to use, but it's true. It's proportionality and necessity around what the business has to do. So any monitoring would need to be justified by a legitimate business interest. So you're making sure that you're preventing data breaches and ensuring compliance with policies, but making sure also to be careful to limit the scope around that, so that monitoring is only of work-related communication, so you steer well clear of the personal, which is tricky if it's a device that is used for work and home, and making sure that a business doesn't stray into accessing any personal information without clear justification. I mean, it's easy for lawyers to say, but it's one of those where taking legal advice at an early stage on what you propose to put in place to ensure that you're legally compliant is absolutely key. Making sure that you're compliant with GDPR and any other relevant regulations within the business, I'd say, is vital.
Yeah, and I guess that's I'd agree in terms of a solid framework. You need a framework and key principles, don't you? Including potentially on the issue we've just flagged of the being clear on what the accepted or the realistic set of communication platforms are, and where, for example, individuals within organizations shouldn't expect any privacy in their messages. Just doing that, even at a human, if not technical legal level, will take some of the heat out if you have actually expressed in advance that you shouldn't expect any kind of privacy on messages in this platform because they're being used for work reasons. Discussions stray between the personal and the technical all the time. If you think of the chat we had, Nick and Holly, before we started recording today, they flow between the two, don't they? So it's kind of just trying to have that authentic, sensible set of principles, I guess. Very good. And both of you this one then, I think, what's the legal, and this is coming back to that tricky, thorny issue around data disclosure duties, who owns what is the legal position on custody of the data, and with it our ability, or one's ability, to control and process it, but also that obligation to disclose when we're dealing with, you might have one example of an individual using their own phone but's got an organization's SIM card in it, which is the thing that links to WhatsApp, and another who's got a corporate provided phone. Who wants to go first? Go on.
I'll go first, and then Nick, feel free to chip in. But I think, the position is generally simpler if the employer owns the device. You know what you can do then. You can provide, it's balanced, but you can monitor that device, and then you would have custody of that data, and obviously then be under an obligation to disclose it in the event of a dispute, whether that's in the civil courts or an employment tribunal. Probably the same is likely to apply where the employer owns the SIM, because it's still information on that SIM card. It's relevant to that SIM card and number. So it's, again, slightly more clear cut. But when then the employer doesn't own the device or the SIM card, and it's an employee's personal device, the employer's not going to they don't process that data of custody of it, generally speaking. So, a personal device would be much harder for an employer to then have access to that information without the employee's consent.
Yeah. I suppose, though, Nick, on the point about if you don't own the device as an employer, you don't have custody and control. You can't stop an individual within your organisation who does own the device being a willing participant in the litigation and disclosing the information, or it'd be very difficult and probably would make the situation look worse if you were trying to prevent relevant material from being disclosed by one of your people. I don't know if you've ever seen that, where you don't have control of the device as the employer entity in proceedings, but one of your individuals, employees, whatever, against whom you're not in dispute, has the device and is obviously maybe saying to you, no, I'm very willing to let you have it and have a look at it. Not easy for a defendant company to then be able to defend, going, no, we don't want to see that, thank you very much, in case it's got something really important in it.
No, absolutely. I mean, we generally see it, and as Holly said, it's much, much cleaner and clearer and simpler if the employer owns the device. But as we know, that doesn't happen all the time these days. And then you have a right to that data. But yeah, where somebody else is offering it up, say you're in a tricky situation as to whether you can't really say no if it's something that's relevant to the dispute and it's there for you. You have an obligation that you need to look at it, and if it's part of the issues in the dispute, you need to disclose it.
Yeah. And the SIM card bit is really interesting as well, that came out of your answer there, Holly. I think that certainly in my experience, I don't see that many clients who are in that middle ground of the two extremes to one side of we give the device and the SIM card, it all belongs to us, the company. The other side of is completely their own device, but they use it for work purposes, of the middle ground, which is quite interesting because it doesn't have quite the same sets of obligations and liabilities around handsets that the company has to make sure have got security patches and update and insure and all the rest of it, but does have some of that greater control, particularly around the phone number, which so something like WhatsApp, it's embedded. You couldn't last time I looked into it. You couldn't use a WhatsApp account unless you had a proper phone number SIM linked to it. So
exactly that. Yeah, I think there's fewer employers in that camp. You're right.
And then here's an interesting one that I just thought I'd throw out there, thinking of it. What happens if the employer pays for a contribution towards the phone? So they essentially pay for the SIM card. So they reimburse the employee. I wonder where that leaves us, because then is it theirs? Is it the employees? So they're paying for the SIM.
I think that could be quite interesting. Yeah, I mean, paying for the SIM probably just enhances your ability to put that policy around it, doesn't it? The framework. Exactly. So you'd start by saying there's an expectation that you'll use via an appropriate device, just for now, for that purposes, to use one of our phone numbers. It'll be provided to you, SIM card. And when you're given it, we pay for it, and you can use it for these or that purposes. It'll have calls and texts or whatever. But here's the parameters of use as well. And obviously the SIM, it just gets trickier every time. Not all data sits on the SIM itself, does it? So the SIM is your gateway into the use of WhatsApp as an employee, but some of the material, well, definitely most of the material won't be on the SIM itself. So you still have an issue of, well, we've got the SIM card back, but it's basically just got some, it's an address book, basically.
Yeah. Some of it sits on the cloud otherwise. And I had it with one case recently where we asked for WhatsApp disclosure, and it was significant, but there was a big period of time that was missing. And we were told that, the phone was destroyed. It was a bit of a Wagger for Christie moment when we were told, whoops, I dropped the phone at that point, and therefore I've lost vital data from the period in question that would prove you're right. And we managed to get IT forensic experts to go into it, and we found it, and it was sitting elsewhere, as you say. It's not on the SIM. It's sitting elsewhere, and that data did exist. It just, had to be found by the professionals.
Yeah. So lots of upsides to having some device ownership, but we've taught it's again controls, isn't it? The point around the returning of devices, and that can result in information passing between employee from a departed employee to a new joiner. You've got to have controls in place if you're passing a SIM across it. They might have inadvertently put personal contacts on that SIM that you've now just passed to a new recruit.
Yeah, exactly. I think that's the trick. And often I think employers don't really think about processes when people are leaving and the return of that device and then what they do with it. Because like you said, they can just hand it over to another employee, might have personal contacts on it. But also it might just be sitting in a drawer and then might have relevant evidence on it, which, either could be wiped without meaning to, or just simply isn't accessed. So I think that's something that's often overlooked when employees leave.
Yeah, there's so much to this, isn't there? But I mean, we're only scratching the surface today, but lots to be looked at by employers to sort of just get a sense, without reaching any data protection laws, Nick, about surveillance of your staff, but get a sense of the up-to-date position on how we're communicating and where, and then do we really set out some clear parameters, including what is intended to be a contractually binding discussion or not, and including what's appropriate sort of content or discussion context and professional or personal around it. There's lots to do there, which guys I'm sure can look quite daunting to an organization in terms of going back in there and grappling with it, but for which they could really meaningfully manage some of their risk and possibly increase their productivity if they're lucky, at the same time, and sort of consistency of approach, etc. Good. Yeah. Well, there's just only time really for one more question, which I'd put to you both. We've talked about balance, and obviously what that represents in an optimal sense will be different for every organisation and its own context. But if you could give one piece of advice, for each of you, on what organisations should communicate to their workers around these messaging services, what would it be? Let me see. Let's go with Nick first.
I'd be saying to the employees, think before you write anything down. really put some thought into it, and forgetting how instant it is and how quick it is. It's impressing on your employees that these communications could potentially be relevant at a later point, regardless of when they're sent, regardless of who they're sent to. So just use some thought around it and make sure that you're complying with the expectations of the business when you are using these communication channels.
Yeah, we've let you set the bar quite high there, Nick. That is a good one.
Yeah, it is.
That's a good one-stop shop one. Go on, Holly. How are you going to?
I'm not going to jump. I wholeheartedly agree, but I think it's also explaining to employees that, even if you think messages are being sent on a personal device of personal in nature, what you send to your colleagues can effectively be an extension of the workplace. And if you say something inappropriate or offensive, it can be, it will be treated quite seriously by the employer, up to, you want to threaten people with disciplinary sanctions, but these kind of things can be quite serious if people are particularly upset about what's been said.
Handle with care.
Exactly, that tread.
Is the
caution.
Collective message. We're all agreeing on that, I think. Right. Okay. Thank you. Thanks both very much. That was really interesting discussion. Lots of things to take away if you're listening and thinking about how this is happening in your organization, or even if you're just working in your organization and thinking, what are the parameters here? What shouldn't be doing to protect myself? A reminder to follow our podcast on LinkedIn and any other platform where you get your podcasts, and on the website there'll be a link to this session today and other materials that you can access around it as well, with a reading list. And we will be back soon.